Hi, y'all, and welcome to tonight's live stream. Two extremely important cases have broken in the final weeks leading up to the trial of Richard Allen. First, there are absolutely shocking allegations against one of the prosecutors prosecuting the case against Richard Allen. The allegations are that he helped file two affidavits without probable cause in a different case, and saying that their allegations isn't really quite correct. A federal court stated this: defendants Lutrell, that's the prosecutor, Krug, and Wisenand are liable under Section 1983 for violating plaintiffs' Fourth Amendment rights by drafting, reviewing, and ultimately submitting an affidavit to a court which they knew they did not have evidence to support. And here's another quote: each of these statements without any evidence to back them up are fabricated statements. So the court found that the defendants, including Prosecutor Lutrell, are liable for several claims. We're going to go into the details tonight. And on the other side of the coin, one of the key witnesses for the defense was arrested. Is this just something to discredit a witness for Richard Allen? Is this Karen Reed all over again? Is there a conspiracy by law enforcement and by the prosecution against Richard Allen, or are these cases completely separate and irrelevant to his case? I'm going to tell you about both cases and then give you my analysis at the end. And tonight is for all the people who have said, oh, Lee must be really for Richard Allen. Lee must be defense oriented, because I am going to give you the unvarnished truth as I see it. I'm going to analyze it straight up. So listen to the end and you'll find out. So tonight we're going to cover four things. Briefly, what happened in Karen Reed. It's like about a minute so you can compare the two. Then I'm going to talk about the allegations against the prosecutor in Richard Allen's case, not in the case, but against the prosecutor who is prosecuting the case. There are three different prosecutors. This is one of the three. The allegations then against a key defense witness, Todd Click, and then I'm going to give you my analysis. I want to say a special shout out to the first five in the live chat tonight: Tina Duer, Taylor Tyree, Bonnie Adema, Chris Ganga, and Bama Queen. Special shout out to all five of you. I am in a new hotel room, as you can see tonight. I had to shift rooms because the judge I am up here in the where the case currently is pending. Now, it's complicated, but the case is actually currently, the hearings and so forth are in Allen County. And that's where there was the jurors were brought in, and the jury was selected from right here, Allen County, where Fort Wayne, Indiana is. Then we are all, jurors included, they're going to be put on a bus or van, and they are going to be driven down to the county, Carroll County, where the crime occurred. Richard Allen is accused of murdering two young teens in a grisly, barbaric killing that occurred back in 2017. And I'm included. I'm all the way up here. I'm hundreds of miles from my home. I'm going to be here for a month because I think this case is that important. It's not televised, and there are a lot of questions and allegations that have been made about whether Richard Allen is receiving a fair trial. I want to know that he is. I think it's super important that people in our country be given a fair trial and that it be public. And that's why I'm here, to be your eyes and ears in the courtroom when we can't have a camera. And it's really, frankly, very difficult to get information about what's happening in the case. So let's dive into tonight. Lee Miller commenting on the courtroom. Oh my gosh. I think that the Allen County Courthouse is phenomenal. It's just gorgeous. I haven't seen the Carroll County Courthouse. I have been told it's very hard wooden seats. So we had a day off today, and I bought a cushion for the very hard wooden seat I've heard about. All right. So quick overview of Karen Reed. In the Karen Reed case, her legal team insisted that she was being set up by a conspiracy of police officers and family members. She was accused of hitting her boyfriend with her car after she dropped him off at a party at some fellow police officers, at the home of fellow police officers. He was found, the boyfriend, in the snow the next morning. He died shortly thereafter. Karen Reed says that the people inside the house, the police officers who knew him, some of whom knew him from work, injured him, dragged him outside, and left him to die in the snow. She, on the other hand, was prosecuted for killing him by hitting him with her car. She said that Trooper Proctor, the lead investigator, was in on the conspiracy against her. A federal investigation uncovered some really appalling and very offensive text messages he wrote about Karen Reed. In fact, I tried simply having the actual statement from the court in my YouTube video, and YouTube demonetized it until I eliminated that. That's how offensive his language was. So is the same thing happening in the Delphi case? Are these cases evidence that Richard Allen is being set up? We're going to take a look at the two cases and whether they suggest any attempts to influence the trial. So let me say thank you to Amanda Thee, who gifted a lawyerly membership. That's awesome. We love our members here. And thank you, Amanda Thee, for gifting the lawyerly membership. And Precocent is appreciating what I'm doing. Thank you. That makes me feel good. Thank you to both of you. All right. So I want to dive now into the allegations against Prosecutor Lutrell. There are three different prosecutors. The chief prosecutor in the case is Nicholas McClelland, who is the elected DA for the county where the crime was committed. But James Lutrell is also involved and also sits at the defense table. He is one of the prosecutors then going after Richard Allen, one of the prosecutors who will be trying the case that will begin on Friday. Now, we've had jury selection. Tomorrow there will be motions, and the jury will be sworn in, and then everybody will truck down to where the crime occurred, which is where the actual trial will take place. So let's take a look at the allegations against Lutrell and ask the question, is it possible that these allegations will somehow come in or help Richard Allen at his trial? And it's important to know, as you kind of think about that and as we talk about it, what I'm about to show you is a civil case filed by an individual. This is not a federal investigation, as in the Karen Reed case. That's where, and by the way, they weren't allowed to say there was a federal investigation in the Karen Reed case. They were just allowed to use the evidence that was gathered in the course of that case. Now, nobody can be, out of the case I'm about to show you, nobody can be criminally charged. This is a civil case. The most that can happen is one side is forced to pay the other side money. This is not something where somebody is going to go to jail. This is a different kind of case. So, and I want to thank Trenton for sending this to me. Thank you very much. So the overview of what this case is about is a doctor says that he was unfairly prosecuted. And the reason he claims that he was unfairly prosecuted is that there was a private company that was being used to take civil funds. It's so complicated. Let me see. Let me break that down further. In the course of a case, the government can freeze assets and take funds that people have that came from the crime that was committed. So let's say you went out and robbed a bank, and then you deposited the money in your bank account. The government could freeze the funds that are in your bank account and say, the reason you have those funds in your bank account is you stole them from somebody else. We're going to freeze those, and we're going to prosecute you on the bank theft that you did. So what they said was that this doctor had been overprescribing opioids, and therefore they wanted to freeze his funds that he had received from the opioids, and they froze all of his accounts, and you'll see the allegations against it. In a nutshell, he says that their reason for doing that was really thin, and you'll hear how he says that the reason it was done was because they had hired a private company to do this forfeiture proceeding, and they were going to get a percentage of the money. So that's his argument. So let me get that. Let me share my screen with you so you can see this complaint. And I want to start with the complaint. It's old, 2020, but there was an order that came out just about 2 weeks ago. And that's what that we're going to talk about tonight. But I first want you to understand what the allegations are. So the case is Economan, and Economan and Associates Family Medicine, and I may not have said that right, and against a number of people, including, and you'll see James Lutrell there, right, the prosecutor who was also involved in the Allen case. Oh, I don't have that on the stage yet. Oh, it says, okay, it's saying it can't access that. Seems like that happened to me one time before, but I don't remember why. Oh, there we go. Yay. Okay. All right. So here we go. And I was just showing you up here the style of it, filed in the Northern District of Indiana. This is a complaint filed in federal court against all of these people. Plaintiffs are a physician and his solely owned medical practice who were falsely accused of operating a pill mill by way of a forfeiture action and criminal complaint, resulting in the seizure and loss of all assets and complete destruction of reputation. So he's saying he was accused of these things falsely. They froze all his assets because they said they were the profits from a crime, and all of this was unfair. And then we're going to unpack what his allegations are. These are the people who are sued. Tonda Cockrell, a sworn law enforcement officer employed by the United States Drug Enforcement Administration and the Kokomo Police Department. She's sued in her individual capacity. And Gary Wiseman, a civilian investigator employed by the United States Drug Enforcement Administration. He's also sued in his individual capacity. The Garrison Law Firm is a law firm located in Indianapolis, Indiana, and hired by the Grant County Prosecutor's Office to handle all forfeiture cases filed in Grant County, Indiana. And then James Lutrell served as the Grant County prosecutor during all relevant times, representing the 48th Judicial Circuit in Indiana. So they go on to say that as the concern over the prescription of opioids grew nationwide, Dr. Economan sought the advice of and employed an attorney, an office manager, a local healthcare specialist, and a medical billing company in order to establish clear office-wide procedures regarding the prescription of opioids. In other words, he's saying he went to great pains to make sure he did not overprescribe, to make sure that he was complying with the law. Now, I'm not making a statement whether he did or didn't. I'm simply saying this is what the allegations in his complaint made 4 years ago were. And then we'll get into the new document that was filed by the court, in order from the court, about 2 weeks ago. This is what the doctor alleges the conspiracy was. And he alleges that the prosecutor, Lutrell, was involved in this conspiracy. In July 2015, local law enforcement, the Medicaid Fraud and Control Unit of the Indiana Office of the Attorney General, DEA agents, Grant County prosecutors, and Joint Task Force officers met to discuss and conspire, upon information and belief, a multi-pronged attack to take down Dr. Economan and EAFM, his company. Upon information and belief, this meeting occurred on July 16, 2015, and was tape recorded. Upon information and belief, the plaintiffs were targeted in large part because the defendants were aware of their financial assets and the potential to seize those assets through forfeiture proceedings. So they're saying the whole reason for doing this was to get the money, to get to the money that he had. That's his allegation. The first prong of the attack would be to seize the financial assets and accounts of Economan and EAFM through the forfeiture process. The second prong of the attack would be to seek summary suspension of Dr. Economan's medical license. On July 29, 2015, local law enforcement, the Medicaid Fraud and Control Unit of the Indiana Office of the Attorney General, DEA agents, Grant County prosecutors, and Joint Task Force officers executed a search warrant on the residence of Dr. Economan and EAFM. The criminal allegations contained within the affidavit used to secure the search warrant accused Dr. Economan of illegally prescribing opioids, or prescribing them without a legitimate medical purpose to approximately 50 of his 2,500 distinct patients. However, the search warrant affidavit was devoid of any real probable cause, and that it lacked any medical opinions or sworn statements from any medically trained individual attesting to the medical illegitimacy of Dr. Economan's prescriptions or practices. So breaking that down, what he's saying is that they decided to go after his assets and then to get his medical license suspended. That would make him essentially defenseless because he wouldn't have enough money to mount any kind of realistic attack. His accounts would be frozen and he would no longer be able to practice medicine. So he's saying this places him in a place where he can't truly defend himself. And that it was done with a search warrant and criminal affidavit, criminal allegations contained within the affidavit that weren't true, that were saying things that were incorrect, or at least were not sufficient. Nevertheless, and on the same day, July 29, 2015, a forfeiture action was filed against Dr. Economan and his company in Grant County, Indiana, under cause number, again alleging that Dr. Economan was operating a pill mill. The forfeiture complaint was filed by the Garrison Law Firm on behalf of James Lutrell, then acting as prosecuting attorney for the 48th Judicial Circuit, in other words, Grant County prosecutor, they call him. And in return for its prosecution of forfeiture actions, the Garrison Law Firm receives a percentage of those funds successfully seized through forfeiture actions filed on behalf of the county. So he's saying, why are they doing this? It's because they're going to get a percentage. Not Lutrell, that doesn't seem to be the allegation, but the law firm that was hired to go after the assets would get a percentage. And then they alleged that there were two separate and distinct probable cause affidavits submitted under the express penalties of perjury. One was by Gary Wisenand and the other was by Tonda Cockrell. And I mentioned them earlier. They were both sued individually in the case. The Garrison Law Firm requested seizure of any and all property, and it was on behalf of the Grant County prosecutor, belonging to Dr. Economan or EAFM, and they said alleged with specificity certain accounts that they believed and had good cause to believe are proceeds from said criminal enterprise. And he's going to say, no, you didn't. You had no reason to believe that these were directly from a criminal enterprise. And he'll go on to say that they took, which effectively served to seize Dr. Economan's entire life savings and all accounts belonging to EAFM, his company. All allegations of criminal conduct were limited to the period of time that EAFM existed, or from December of 2012 to July of 2015. Nevertheless, included specifically in the seizure order were two separate IRA accounts that were established in the 1980s and had received no deposits, contributions, or withdrawals in the previous 5 years. So he's saying you weren't carefully looking at whether or not there were funds that actually had moved from this alleged criminal enterprise, which he says wasn't even a criminal enterprise, but you weren't even looking at whether or not the criminal allegations related to these accounts. You just took everything. So he's arguing you can't do that. There were some that were so old, they clearly had nothing to do with this particular allegation. In August 2015, the defendants began the second prong of the attack. On August 26, 2015, Jessica Krug sought an emergency suspension of Dr. Economan's medical license. And now skip a little bit here. They appeared before the board. And in fact, what happened, Wisenand said, and during questioning before the board, that Economan was the third highest prescriber of controlled substances in Indiana, and that the deaths of certain patients could be directly attributed to Dr. Economan's prescriptions. Neither, and the allegation here is neither of these statements were in fact true at the time they were uttered under penalty of perjury. So these statements were made under oath, but he's saying they weren't true. It wasn't accurate. And he did, in fact, lose his license and said he never practiced medicine again. This was the end of his medical career. Cockrell affidavit, he next talks about that and says the probable cause forfeiture affidavit submitted by Cockrell consisted of 2 pages, and she alleged under the penalties of perjury that through her investigation, she identified certain accounts containing significant funds that are proceeds from the criminal enterprise described in the affidavit of Agent Wisenand, DEA. So there was first the affidavit from the agent Wisenen, and then she said, yeah, these accounts I've listed here, these are the ones connected to the crime. And this complaint says, no, they weren't. And you had no real reason to believe many of these were connected in any way to what you were alleging. On October 2nd, 2018, Cockrell conceded in her sworn deposition that the information contained within her July 2015 affidavit was false. Now, I will say this. Reading statements like that in a complaint, I often kind of discount that. Lawyers make very broad statements, maybe oversell it a little bit, but you'll see a lot of this repeated in the order from the court. So that means the court has made a finding on some of these things. I don't remember if that exact statement was, but I'll show you in just a minute the order from the court and what that says about it. Specifically, Cockrell admitted that she had no information to support her statement that Dr. Economou's accounts contain significant funds that are proceeds from the alleged criminal enterprise. I'll go ahead and read the rest. Described in the affidavit of Agent Wisenen at the time she swore and affirmed the same to be true. In fact, the only information Cockrell knew concerning the existing financial assets and accounts of either Dr. Economou or EAFM when she submitted her signed affidavit to the forfeiture court consisted entirely of 7 pages of documents that were acquired by law enforcement after conducting a trash pull on Dr. Economou's residence on July 14, 2015. Little known fact, your trash, once it's outside the actual property on which you live, is considered public property. And so they went through the trash and they pulled out documents. And they're saying all she had was 7 pages from that. She didn't have any more than that. And I'll skip that next paragraph. And they say no further information regarding the plaintiff's seized accounts or their contents was ever requested by Cockrell or Wisenen. Moreover, Cockrell confirmed that even as of the date of her deposition, October 2nd, 2018, so 3 years later, she still has no information that would support the sworn statement she made on July 29, 2015. Moreover, and despite admitting that she had in fact signed the false affidavit under the penalties of perjury, Cockrell testified at deposition that her affidavit was actually created by Garrison and or Taylor of the Garrison law firm. So she's saying she didn't even write this herself, that it was written for her by the Garrison law firm, which was then going to receive a percentage of the funds that it collected. That's what the allegations here are. Specifically, Cockrell testified that the Cockrell affidavit was prepared by Mr. Garrison, prepared by Mr. Garrison's office, and that I added the and, that there was a gentleman from Mr. Garrison's office that prepared the Cockrell affidavit, and that someone in Greg Garrison's office prepared the Cockrell affidavit. Cockrell testified, I did not write those words. And then there are very similar allegations made about the Wisenen affidavit. The probable cause affidavit submitted by Wisenen alleged incorrectly that Dr. Economou issued more controlled substances than any hospital group in Indiana, to include Eskenazi Hospital, IU Health Hospital, and IU Methodist Hospital, all of which are major hospitals located in downtown Indianapolis, by a margin of at least 8,000 prescriptions. And he's going to say that's simply false. Wisenen alleged that supporting information from INSPECT, Indiana's prescription drug monitoring program, was obtained pursuant to a DEA administrative subpoena in June 2014. This was not a true statement. So they're saying there was this claim that we had a basis for what we were telling the court, and they didn't. They didn't have a basis for that. That's what the allegations here are. In other words, the INSPECT data actually revealed that Dr. Economou was issuing prescriptions for controlled substances at a similar rate as physicians still in residency who had yet to apply and receive their own DEA number. His assets were unlawfully seized for nearly 4 years, 1,283 days, and only then was the forfeiture claim dismissed with prejudice, voluntarily dismissed with prejudice. As a result, Dr. Economou lost his home of over 30 years through foreclosure and sheriff's sale. And his company was no longer able to operate, immediately ceased operations. He was forced to sell the majority of his unseized personal property to pay for his defense against demonstrably false allegations. In short, he lost his home, profession, business, life savings, and reputation in the community due to the above-named party's misconduct. So these are just, I'm pretty sure, there was a little bit more I wanted to read to you. Plaintiffs allege that the Grant County prosecutor, that's Lutrell, the Garrison Law Firm, and the Medicaid Fraud and Control Unit of the Office of the Indiana Attorney General, acting under the color of Indiana law, conspired to manufacture and or fabricate evidence against the plaintiffs and their property prior to having probable cause, and by so doing violated their rights to due process, et cetera, et cetera. Additionally, they allege that defendants, including the Grant County prosecutor and all the others they just mentioned, engaged in a conspiracy to unlawfully seize the plaintiff's property for the purpose of earning a percentage of the illegally seized property. And finally, they allege that they, acting under color of law, jointly and individually failed to intervene in a knowing violation of the plaintiff's constitutional rights. So let's talk for just a minute about what we just read. Okay, and thank you, Taylor, for the super sticker. I appreciate that very much. So what this is about, the doctor is saying you literally made up stuff and put it in affidavits in order to get permission to seize all of my assets, which you took, you kept them for 4 years, and then said, oh yeah, sorry, we had no basis for this. That's what he's saying here in this complaint. We're going to see which of these claims actually held up, because just 2 weeks ago, there was an order from the court in a summary judgment motion. Now, what that means is there are allegations that are made by the court, allegations that are made at the beginning, but they aren't tested yet. Nobody's ruled on them. Nobody said these are true. These are just things the plaintiff, in this case, it's a civil case. The plaintiff comes in and says, these are what I think is true. And then there's a process. Everybody goes through some discovery. There are some documents produced back and forth. Depositions are taken. And then there is often in these cases, there's a motion for summary judgment. That's where each side, one side, whoever filed the motion for summary judgment, says, look, we can take a look at all of the evidence here that everybody agrees on, and we can look at the law and we can see that there's just not a case here. That's what the defendant would say. Or the plaintiff would say, we can see that I've proven my case and there's nothing, absolutely nothing they could say that would cause this to go away. Usually summary judgments are filed by the defendant, and the defendant says there's just nothing here, Judge. They've done their best. They just can't meet the elements of this claim. There's no way they can do it. There aren't enough facts out there. Even if you believe every single thing they say, there just aren't enough. And so that's what a summary judgment is. Everybody puts the evidence before the court, hasn't gone to a jury yet. A summary judgment will be ruled on by the court, and the court will either say, yeah, this needs to go to a jury, and I think there's enough dispute between the parties, a jury ought to make a decision. Or we'll say, you're right. This is all over. This is some summary judgment, and I'm going to go ahead and make a decision here. And in this case, the judge made what is kind of an unusual decision in favor of the plaintiff for summary judgment. That is not normal. Almost all summary judgment motions come from the defendant saying, get rid of this case. There's nothing here, Judge. There are a few cases where the plaintiff will file a motion for summary judgment, and it happened here, and the court ruled with them. So let's back up a little bit and talk about, remember, our focus is on the Richard Allen case. What you have just seen is allegations that a prosecutor in the case created affidavits and made up facts. He was involved in a group that did this in order to steal somebody's money. They weren't real. They weren't accurate. This person was being prosecuted for no real reason. There was no factual basis for it. How you can see immediately where that could go. That sort of reminds me of what happened in Karen Reed's case, what her allegations were, and you can see where it might make a difference in Richard Allen's case. But I'm going to talk to you about why I don't think it will at the end of this. First, though, let's look at what the judge ruled. This is a very unusual order, and I tell you that because of the fact that this is actually granting the summary judgment of the plaintiff in large part. So I just have a few sections in here I wanted to read to you so you can understand. Now, I wanted to read this paragraph to you because there was a little more to it than it sounded like when you just read the complaint. And they talked about around the time the Medicaid Fraud Control Unit received that complaint, Defendant Cockrell received reports from a printing company that plaintiff Economan was ordering large numbers of prescription pads for controlled substances. We'll skip that next. After learning her colleagues made undercover buys of controlled substances from plaintiff Economan's patients, she and defendant Wisenan, a longtime DEA officer, interviewed the printing company who reported the large orders of prescription pads for controlled substances. They also interviewed pharmacies who reported concerns about plaintiff's prescribing habits. So those were the facts they had and the things they were looking at. Then let's hear what the court said after looking at the facts as they were submitted by both sides for this. All right, beginning with defendant Wisenen's affidavit. His was written with defendant Krug's assistance and reviewed by defendant Lutrell. That's the prosecutor. In his deposition, defendant Wisenen admitted, this is the court writing. This is no longer the plaintiff writing. This is a federal district judge writing this. Defendant Wisenen admitted he had no evidence, let alone probable cause, that plaintiffs committed the criminal offense of corrupt business influence, despite the allegations and conclusory statements in his affidavit. Defendant Wisenen also admitted he had absolutely no evidence that plaintiff committed Medicaid fraud when he swore and affirmed to the same. That's shocking to me. I'm just going to say that is absolutely shocking that the federal judge is actually finding that there was an admission by defendant Wisenen that he had nothing. He did not have the evidence. He did not have the probable cause, and he filed it anyway. Finally, defendant Wisenen admitted he had no evidence that plaintiff Economan was involved in money laundering. Defendant Wisenen also included inspect data in his affidavit, despite his and defendant Cockrell's joint knowledge that inspect data was not permissibly used as evidence. Defendant Cockrell's affidavit fares no better. Although her affidavit was prepared by defendant Garrison Law Firm, defendant Cockrell still signed it, affirming the truthfulness of its contents. Her affidavit is focused entirely on the bank accounts that allegedly contained proceeds from plaintiff's criminal enterprise. However, defendant Cockrell has too since admitted her affidavit was inaccurate in stating she had good cause to believe that the account seized from plaintiff contained significant funds from a criminal enterprise. I mean, absolutely shocking. Of the 8 accounts seized from plaintiff, defendant Cockrell admittedly had good cause to believe that at most 2 of the accounts contained significant proceeds of a criminal enterprise. This is truly amazing. She's saying that she admits that she took 8 accounts and at most 2 of them could have contained significant proceeds of a criminal enterprise. She's saying she was inaccurate in saying that she had good cause to believe the accounts contained significant funds from a criminal enterprise. And the court is saying that. The court is saying, I find this. This is what the evidence shows. And keep going. The evidence demonstrates that defendants, remember Lutrell is one, did not have probable cause, let alone a preponderance of evidence that plaintiffs committed the offense of corrupt business influence or any other crime, which would make a civil forfeiture proceeding appropriate. These are really strong findings. These are very strong findings by a federal judge, and that is very, very serious. But I'll talk in just a minute about what I think related to. There's not much left to read on this. The court begins its analysis with defendant Wisenen's affidavit used for the civil forfeiture order and search warrant. It was written with the assistance of defendant Krug and was reviewed by defendant Lutrell. Inspect data, as discussed above, is not appropriate to use as evidence. The interview summaries of plaintiff's former colleagues and patients and family members of former patients are nothing more than allegations, which does not put forth sufficient evidence to induce a reasonably prudent person to believe that a search will uncover evidence of a crime. Eliminating the statements defendant Wisenen admitted he had no evidence to support and removing the inspect data strips his affidavit of details essential to the finding of probable cause. In other words, I look at what's here. The judge says there's nothing here to support probable cause. Plaintiff's motion for summary judgment on the Fourth Amendment claims is granted. This means that the plaintiff is actually winning this against defendants Lutrell, Krug, and Wisenen are liable. So it's not just that it's going to go forward to trial. The judge is saying, I actually find you liable. I find you responsible. That's what the judge is saying here. Under Section 1983, for violating plaintiff's Fourth Amendment rights by drafting, reviewing, and ultimately submitting an affidavit to a court, which they knew did not have evidence to support. They did not have evidence to support. Wow. Here, plaintiffs allege that defendants fabricated evidence which resulted in their unlawful seizure. In defendant Wisenen's deposition, he admitted to including conclusory statements in his affidavit that were not supported by evidence and which did not create probable cause. Defendant Wisenen also admitted he had absolutely no evidence that plaintiff had committed Medicaid fraud when he swore and affirmed to the same in his affidavit. He had no evidence, swore to it anyway. Finally, defendant Wisenen admitted he had no evidence that plaintiffs were involved in money laundering. Each of these statements, without any evidence to back them up, are fabricated statements. Wow. Under Fields, these are violations of the Fifth Amendment, and again found the plaintiff's motion for summary judgment on the Fifth Amendment claims is granted. Plaintiff wins those claims, is what he's saying. Motion for summary judgment granted. Defendants Lutrell, Krug, and Wisenen are liable under Section 1983 for violating plaintiff's Fifth Amendment rights by drafting, reviewing, and ultimately submitting an affidavit to a court containing unsupported information, which was then used to deprive plaintiffs of their property. Here, a medical doctor with the ability to prescribe narcotics was charged with dealing a controlled substance and corrupt business influence. These charges were dismissed only because he voluntarily pled guilty to possessing marijuana, and his punishment had to retire his medical license. So he's saying that that doesn't rise to the level of cruel and unusual punishment, which it really wouldn't. Let's see. We'll skip that. This was just saying, in this matter, defendants clearly had a rational basis for instigating the criminal investigation of plaintiffs. In other words, going ahead and doing an investigation, you had enough for that. So the judge is agreeing with the decision to investigate it. It's the affidavits and taking it further that he or she is objecting to. After the search warrant had been executed and the civil forfeiture had been filed, but still before criminal charges were filed, defendant Lutrell specifically instructed defendants Wisenen and Cockrell to conduct certain additional interviews and investigate other specific items. Defendant Lutrell does not appear to this court to have been acting in a purely prosecutorial manner. He seems to have been intimately involved in the investigation from early on, going so far as to direct it at certain points and cannot be afforded absolute immunity. All right, I'm going to skip that. I think I'll go ahead and pull out and let's just talk. So these are really serious allegations, and the court is finding summary judgment for the plaintiff against the prosecutor. So you can see where you conceivably, this could be something that would be a Karen Reed kind of thing. Maybe this prosecutor is out there prosecuting not just this person, but other people with no basis. Maybe there's some other grounds that he's doing this for other people. But I don't think there's any evidence of that, and I don't think this will affect Richard Allen's case. And let me talk for just a minute about why I think that. I mean, it might seem like if you'll prosecute one person falsely, well, who else would you prosecute falsely? Who else would you make up evidence for? Would you file an affidavit without basis for? But in this particular case, I think it's going to be not something that Richard Allen is going to be able to use in his case. First of all, this is not related to Richard Allen. In Karen Reed's case, the federal investigation may or may not have begun by looking into the Karen Reed case, but it ultimately reached that stage. Proctor made statements about Karen Reed. The allegations against Lutrell, though, aren't specific to anything having to do with Richard Allen or his case. And Lutrell is not a party to the case. He's an attorney in the case. So I don't think that there's any way that this evidence or anything about this case comes into evidence in Richard Allen's trial. There are also some really key differences between what happened in the Karen Reed case and what happened here. Now, this case is filed in federal court, but this is not an investigation by any federal government or agency. This is simply a civil suit filed by an individual who filed it in federal court. Nobody can go to jail for this. As I said, it's a civil case. If there were some underlying federal or state investigation, maybe things would be a little bit different, but there's no indication that anything like that is going on. There was simply one instance where this court has found that there was an affidavit that lacked sufficient basis and that he could, in fact, found that he and others would be liable for that. This is just a summary judgment, not a final judgment in the case. That will be something that will go forward. It's summary judgment only as to the issues that the court ruled on, not as to everything. It's not all over yet. For one thing, no damages have been assessed. There hasn't been a finding about how much the plaintiff lost or what value it would be. So they are, though, very serious allegations, and they certainly matter. The fact that summary judgment was granted for the plaintiff is very unusual, and I can understand why people would wonder about that. But for right now, I think there's zero way that Judge Gull would let it in, and I think that's probably correct because I don't think it has anything to do with Richard Allen's case. I don't think it's connected, and there's no basis for connecting what happened in that case to what happened in this. So it came out just 2 weeks before Richard Allen's case. Now, could there be some kind of plot to bring this out to discredit the prosecutor right at the right time? I think that would be pretty unlikely. And the reason I think that is because of the fact that this is a federal judge. The case against Richard Allen is going forward in state court. And I just don't think there would be enough connection between the two. I mean, it's possible, but I think it would be very, very unlikely that there would be any connection time-wise, that it would be intentional. I think that there was just briefing and the judge got around to ruling on it when the judge got around to ruling on it. So the second person I want to talk about, thank you, Melody, tore my pillow cost. Yes, we do need to protect my back and hip. I am a little worried about that. I've heard all about those benches there in the Carroll County Courthouse. So the next person I want to talk about is one of the most important witnesses for the defense. And I'll tell you why I think he's so important. His name is Todd Click. We're going to take a look at why I think he's so important by looking back to the Franks memo. Let me add this to the stage and flip over to the Franks memo. So, and I want to just read, I'm just going to read just a few excerpts. We've gone long tonight. Okay. These are, the person is Todd Click, and the reason why this is relevant or important at all is Todd was arrested and charged with crimes about 3 weeks ago, just shortly before the trial of Richard Allen. And he's a really important witness for Richard Allen. So is there some movement afoot? Was the timing of that a coincidence, or is this all an attempt to discredit one of the key witnesses for Richard Allen? And he may not actually be all that important, given that Judge Gull has said that Richard Allen cannot put in the Odinism information at trial. But if she changes her mind, or even for purposes of the proffer, all of this is important. So let's take a look at why Todd Click is important in the case of Richard Allen, the defense he wants to make. This is the Franks memo filed by the defense when they first dropped all of the bombshell information about the scene of the crime, about how the FBI initially believed that this was potentially a crime by Odinists, that this was a crime by a group, that it may have been part of a pagan ritual. None of that was confirmed in any way, and suddenly it was dropped in this motion right here. And Todd Click was an important part of that. Thankfully, during those passing years, law enforcement officers Kevin Murphy, Greg Ferenczi, and Todd Click continued to pursue the truth. Because of their curiosity and investigative efforts, the evidence establishing the names of the likely murdering members of this Odinite cult became known to the Delphi investigative leadership no later than February 2018. Due to either incompetence or a concerted intentionality, those in charge of the investigation refused to arrest or even properly investigate these obvious suspects. And they talk about a letter from former Rushville Assistant Police Chief Todd Click, who worked on the Delphi murder case. After reading Richard Allen's probable cause affidavit, Click became concerned that the information contained in Richard Allen's affidavit, pointing the finger at Richard Allen, was far less compelling than the totality of the information that Detective Ferenczi, Detective Murphy, and Officer Click had accumulated during the Rushville portion of the investigation. Click's concerns led him to seek out a lawyer to assist him in the drafting of a letter. In other words, he looked at the affidavit saying, this is why we've arrested Richard Allen. And he thought to himself, you got to be kidding. That's not that strong. That's nowhere near as strong as all the evidence we were working on related to Odinism. He felt so strongly about it that he sought out a lawyer to assist him in drafting a letter. This letter was not provided to the defense until after it was obvious from the last round of depositions that the defense, who had doggedly pursued witnesses as far away as Georgia, would certainly be talking with Todd Click. McClellan had this letter in his possession for over 4 months before turning it over to the defense. They also withheld several other exculpatory pieces of evidence, the prosecution did, including an 85-page compilation of reports by Click prepared in 2019 and several videos containing statements that support the defense theory of Richard Allen's innocence. According to the summary of Click's investigation that he attached with his letter, the Behavioral Analysis Unit of the FBI determined that the individuals responsible for the homicides were involved in Nordic beliefs. This was news to the defense. And you can see what an unbelievably strong statement that is. They are saying shockingly that this crime, even the FBI believed it was committed by this group of Odinists, that the FBI actually had determined that the individuals involved in the homicides were involved in Nordic beliefs. And that the defense is both upset that the information was withheld and they believe it's exculpatory, meaning it makes it less likely that Richard Allen is guilty. It helps him get off and to say somebody else did it. And Todd Click is in the middle of this. Todd Click is the one explaining that, hey, wait, you need to look at what we were deciding and what we were looking at, and that the Odinism theory that we were pursuing. The letter that Click sent to McClellan was the first time that the defense has heard that the FBI actually believed that Odinists were likely involved. We'll skip the rest of that. And we'll read down under Carroll County Sheriff Tony Liggett failed to include all this Odinite information in his October 13, 2022 affidavit for search warrant, which they will say then meant he didn't give the court enough. If he had told the court the whole truth, they say, then there would never have been a search warrant that was issued that allowed them to go search Richard Allen's home. That's where they found the gun, which they connected to the bullet that was between the girls. Richard Allen has zero connections to any pagan cult or pagan cultists, and furthermore, no forensic evidence such as DNA or electronic evidence links Richard Allen to the girls or to the crime scene, i.e., he is a completely innocent man. And we'll go ahead and stop there. So this Todd Click's role is important in showing several different things. First of all, that there was an investigation and there was concern within the group. There was a large body of people investigating and deciding whether or not there had actually been who killed these two girls, who was responsible for this. There were many different people involved, many different agencies involved in the investigation. And the FBI and at least Todd Click and others all believed it had to have been something related to Odinism. He felt so strongly about that when Richard Allen was arrested, he actually wrote the prosecutor and said, wait, you're missing something. There was this really important theory we were following, and we believe it was Odinists. We don't believe that it was Richard Allen. You don't have enough evidence here. That is critically important to the defense on multiple levels. It's critically important on whether or not there was a sufficient amount of information given to the court that issued the search warrant. It's also relevant to the issue of whether or not there was enough investigation done by law enforcement when they looked into who committed the murders. And of course, it goes to whether or not Richard Allen is guilty at all. Now, the judge has said, this is not coming in. I am not going to permit you, Richard Allen, to talk about the third parties who might have committed that. I have said for numerous videos now, I don't understand that. I find that I think it was a mistake to do that. And the reason I think it is a mistake is because I think it really makes it far more likely that there will be a reversal on appeal. And because I think that Richard Allen has a constitutional right to argue that other people committed it. And the fact that there were numerous investigators involved who thought it was a credible and reasonable theory means that this particular theory should be one that Richard Allen should be allowed to present at trial. The judge kept it out and said that there wasn't enough connection between these crimes and Odinists, or proof that there was some reason, some basis to believe that Odinists committed the murder. Personally, I felt like they had put enough in, but that was the court's ruling. So, okay, that was the court's ruling. Now let's go to what happened to Todd Click, because suddenly he was arrested just a matter of about 3 weeks, less than a month, before Richard Allen's trial was to begin. So let's take a look at what happened to him. And these are quite serious allegations. This is the probable cause, and I'm just going to read a few paragraphs here. It's not very long anyway. On April 11th, 2024, the OIG received a complaint from the Indiana Department of Child Services, DCS, alleging that a former DCS employee, Todd Aaron Click, submitted official reports in his role as a family case manager to the DCS case management system. According to DCS, these reports contain false information of family visits and DCS documents with forged signatures of parents' caregivers. I was assigned to investigate this case. And what they go on to say is that Click was employed with DCS, and his role was, when there was a call into DCS, he was supposed to go out and talk to the family. So sometimes these would be complaints that something was happening to a child. It could come from the school, or it could come from the parents who needed some kind of help or assistance, or wanted to lodge a complaint against someone else. During my investigation, I found evidence that Click falsified at least 10 magic entries. Those were documentation of what work was being done, and forged the signatures of parents' caregivers on at least 7 DCS forms required during the assessment process. And they go through a list of these. Click reported in Magic that he made a visit to MB's home in Batesville, but didn't find anyone home. Click said he called MB on the telephone and was told by MB that she was on the way to Ohio for a family Christmas. MB said that call never happened. And they go on through other families, same thing. AB said this visit never happened. CM and MW both said the visit never happened. Sorry, CW and MW both said the visit never happened. And then down here, I believe Click knowingly and intentionally created written instruments purporting to be signed by parents or caregivers, all without authority to do so, in violation of Indiana code for there's the statute number, forgery, a level 6 felony. And there are more facts under here. This one, Click submitted to DCS a tribal membership form required by DCS and reportedly signed by MB on 12/28/2023. This date corresponds to a date in which Click reported a visit with MB at her Batesville home. MB said the visit never happened, and she never signed any form for Click. I showed her the form, and she confidently said, "That is not my signature." So here, Click is being accused of what's really a pretty serious and appalling crime, which is when you had a problem and you called DCS, DCS is supposed to go out and investigate to protect children, to make sure nothing terrible is happening to children. He was supposed to do that. He was the boots on the ground guy. He was the one who was supposed to go out there. And what was happening was he wasn't. He was making false entries saying that he did, and he was also forging family signatures when he needed them to sign a document. These are just allegations. None of this has been proven, but they're obviously serious claims against Todd Click. So an obvious question is the timing of this right before Richard Allen's case suspicious? And because it does seem like they have a lot of incidents in there, and it seems as if they have a good number of them that do seem real. They have enough in there that it would probably be considered pretty likely that there may be some kind of result, whether it be a plea or some kind of guilty. At a minimum, they have enough to go forward with the case against him. So is it suspicious, the timing? And just a matter of weeks before Richard Allen's trial, given how important he is to Richard Allen's case. This is at least the same system. It's not federal court. This is state court. But they do have a lot of allegations, and they say that the investigation began in April. That's months after that September Franks hearing filed in 2023, September. This was April of 2024 when they first got a complaint and say they began the investigation. So it seems unlikely to me that there's any kind of plan to do this right before the trial. I mean, maybe they rushed it and put it through right before the trial, but it seems as if it has real teeth to it, and that he, in fact, will have something to answer for. He may have a great defense. We don't know that yet because all we have is the government side of the case so far. We don't have anything about what he claims it is. So let's think about whether either of these two things are going to really impact the trial. With Todd Click, the defense has now asked to be allowed to use the testimony at the hearing. Todd Click testified at the hearing, the 3-day hearing that took place, and he was cross-examined by the state. And at that time, there was nothing out from under seal about this investigation that was going on. So it didn't include that. The cross-examination did not include anything related to these charges, and they haven't been proven yet. In many states, they would be irrelevant for right now because they haven't been proven. They are against a law enforcement officer, and they would relate to his credibility, but they haven't been proven at this stage. There's not been a finding. There's not been a plea. There's not been any kind of adjudication of it. There's just the charge. That's all there is. The affidavit that you saw, that's all there is. So at this point, I don't think that will have any impact on Richard Allen's case, because I don't think they'll be able to. I don't think they plan to bring him for the Odinist part of the case. I think they plan to use his testimony, and the judges kept it out. As far as the other matter, I've already explained why I don't think that prosecutor issue, I don't think that will have anything to do or will result in any effect on Richard Allen's case. I think those are really serious allegations that the federal judge made in that order, but I don't think it will directly impact what happens with Richard Allen. So I will take a few questions if you have any. So go ahead, if you would, put question marks right at the beginning. And thank you, Kelly Edwards, for the super sticker. I appreciate that very much. And Jackie P has been a member for 8 months. It must be our 8-month crossover, because that is the first 8-month one I've seen, I think. So thank you, Jackie P. You were there from the very beginning. I appreciate that. All right, so let me head over and see if you have any questions at the beginning by putting your question marks at the beginning. And let me talk for just a minute about what's next, too, because tomorrow, as I said, there will be hearings, and there will also be the jury will be sworn in, and everybody, after the hearings are over, the jury will probably go straight down to Delphi. I think they're actually staying in Lafayette, nearby Delphi. and they'll be going to their hotel where they will be sequestered for an entire month in the presence and company of the bailiffs. They will not be allowed out. They are going to have family visitation once a week so their family can come down and visit them, which would especially be important for the ones with little kids. It seems like a real hardship to be away for a month. They are going to be each day coming over to the Carroll County Courthouse, and they'll be hearing the case and making their decision. So all of that will begin on Friday with opening statements, with the beginning evidence presented by the prosecution in the case against Richard Allen. Tomorrow will be the jury getting sworn in and the motions that we're going to hear. So that is what we can expect. Molly asking me, are there family members in the courtroom? There have been some family members in the courtroom, but it hasn't been a large number. This was only jury selection. I would expect there to be significantly more as we move into the trial, and they've set aside a pretty large number of seats for the family members for both sides. All right, so let's take a look at what other questions. How much bias are you seeing from the judge? What effect will that have on the jury? So during jury selection, which is what I've seen so far, I did not see a lot of bias from the judge. I didn't see that happening at all. But I will say this, all of the arguments about whether or not the particular jurors should be struck for cause, those all happened out of our presence. They were done up at the bench. So I have no idea how she ruled. She could have completely ruled against the defense every time, and I would have no way of knowing that. All that happened was they came back and the judge told us which jurors would actually be seated. That's all that happened. So we didn't get to hear the actual argument. Now, so that would be my answer as far as how the trial has proceeded so far. Ginger, is the other court really 2 hours away? Are you moving to a closer hotel? Yes, I am definitely moving to a closer hotel. I don't know exactly how far it is, but it's a goodly distance from what I understand. The judge said 2 hours. Savannah Gary, have you visited the bridge? I've not visited the bridge, which, by the way, is different from what it used to be because they've torn down part and erected a new one, but I think it only goes partway across right now. Someone said you can climb over from one part of the bridge to the other. I thought that is not what I'm going to be doing. I would definitely fall to my death on that. Susan Moore, is Prosecutor Lutrell still a prosecutor? Yes, in fact, a prosecutor in Richard Allen's case. He is actually one of the prosecutors sitting on Richard Allen's case. Maria Z asking about how is dinner? That's actually tomorrow night. Have my days all mixed up. But I'll still be going live. I'm still expecting to go live tomorrow night. All right, to let you know about what happened in the motions, there are some really important ones that we'll be hopefully getting final rulings on as we move into the trial. So that is, in fact, what I'm going to be doing next. I'm going to be preparing for tomorrow, even though it's not my motion. I want to make sure I know all the arguments on both sides so I can get that out to you quickly and do a live from that. All right. Melody, will the jurors have to eat all meals together? I guess so. I mean, they might be given food in the evenings and they can go to their own rooms and eat. But in general, they're going to be spending an entire month together. There was some question about, you're going to be spending a month around these other people. How do you feel about that? So it is definitely what's going to happen. Lori Wallace is asking me about the demographics of the jury and will they be able to ask witnesses questions? The demographics were more women than men. It's a little hard to say exactly because some of them are alternates, some of them are jurors, and they added an extra juror at the end. So it was not clear whether the judge had just decided, hey, let's have an extra alternate, or whether the judge had decided whether someone had been removed and we just didn't know which. So I can't tell you the exact makeup, but there were more women than men. All right. And will the jury be able to ask witnesses questions? Yes, they will. And there was a statement by the judge that they were actually going to be able to do limited deliberations in between, like during breaks or maybe even overnight. I don't understand that. And she may explain that more. To a couple of us back there were talking about that. Did we hear that right? Did we understand that? Because it just seemed so unlike my experience where jurors are asked to don't say anything, don't talk about the case or anything until you are actually back in the room with the other jurors. So it will be a little bit different process, or she may explain it. We may have misunderstood. That's what the two of us got. Have you met or run into Andrea? I have. Yes, I have I sat by her. In fact, Anna, can you think of any other case that's similar to this? No, this is a wild one. This is an absolutely wild case. The allegations in this are crazy. Anyone from Lafayette area remember Pizza King? I don't know about that. Is that something you recommend or don't recommend? Please let me know. Put that in there. Yes, Bob Mata is we're going to dinner. Yes. Okay, let's see. Courtney, how about the timing of arresting Allen days before the sheriff's election? That has been a huge issue that was raised even recently by the defense in one of their motions. Justice isn't always fair, and if he walks, it's too bad, says Courtney. Yes, you can't run investigations in this manner. So the timing of the arrest, the defense has always said was related to the sheriff's election, and that it was a need to get something done in Delphi. There was a change in administration in that the sheriff was retiring, and he had somebody apparently in particular he wanted to win, and so they arrested somebody. That's been the allegation from the defense team. Let me head over here and make sure that I have thanked everybody. Criminal Network is a new member and a very nice member, having already gifted 10 lawyerly memberships. Thank you, Criminal Network. I appreciate that. And Bama Sin has been a member for 3 months, and I'm happy to bring you this trial. I am really interested in this. I am very interested. I am going to give you as much as possible the absolute unvarnished truth of what I see in the courtroom. That's my plan. Unvarnished truth. What are we actually seeing? What is an analysis of the witnesses, of the arguments, of the rulings of the court to the extent they're made in our presence? I will give you all of that. And I think this is really important. I do think this case says a great deal about who we are and what we believe. And it has a lot to do with whether or not we really believe that people deserve justice, and that includes the defendant as well as the victims. This is a horrific case. I cannot say more strongly how much I believe somebody needs to be in prison forever for this. And if Richard Allen is proven to be the guy who killed them, then I will be first in line to lock the door and to throw away the key. That is what needs to happen. But I do think that he has to be given constitutional rights in the process of law. That's what our nation requires. And so that is one of the reasons I'm here. It's not a televised trial, and it's difficult to get information. So I'll be the eyes and ears telling you what happens in the courtroom. I hope to be able to get in every day. I'm not sure. I've been told the courtroom is tiny, that it will be very difficult to get in, and I'm just going to do my best. But I have come all this way for a month because I think it's really important. All right. Well, we will call it a night, and I will be with you again tomorrow night. I don't know from here on out exactly what time I'm going to go live. As you know, we try really hard to go live at 7 p.m. Monday, Wednesday, and Friday. It's going to be much more often during the trial, and I don't know that it'll be 7 p.m. It's going to depend on when trial gets out and how quickly I can get back to my room and go through and highlight my 31 pages of notes from that day. So I will do it absolutely as quickly as I can, but I don't know for sure by the time I get down tomorrow night what time it'll be. But I will see y'all tomorrow sometime.